I'm Alex here from Knight Evans, and I'm joined here today by our lettings manager, Victoria Whitlock, and we're here to talk about the Renters' Rights Act, not to be confused with the Renters' Reform Bill.
Yeah.
What is the difference, first of all?
The original Renters' Reform Bill was introduced by the Conservative government, and then obviously when Labour got in, they made amendments to it and changed the name into the Renters' Reform Bill. So they made several amendments to it, but it's
kind of the Conservative bill, but rebranded by Labour, and there's a bit of politics. They thought we'd change the name.
They changed the name.
But the content,
pretty much the same.
Any differences?
Not really. Pretty much the same. You know, nothing really. It's the biggest changes for many years. But in all honesty, I don't think anyone's got anything to worry about with it really.
So let's start with what is changing.
Main thing, and I think this is what is frightening people, is the end of the Section 21 notice. Basically, no fault evictions, and that's what's really being branded out there. And a lot of landlords are worried that they're not going to be able to get tenants out. You still will be able to get tenants out, but it's strengthening the Section 8 notice to be able to do that. If you want to sell your property or you want to move back in, you'll still be able to do that. And obviously, if they break any terms and conditions in their tenancy agreement or in fact in renters' arrears, you'll still be able to get them out. So there's nothing really to worry about.
So Section 21 as it stands today, you describe that as a no-fault eviction?
Yes. Basically, if you want your tenant out, you give them 2 months' notice, and then if they don't get out, you go to court. You don't have to give a reason.
Okay. Whereas now you can't serve notice without giving a reason.
Well, you can now, but as from May the 1st.
From May the 1st, you can't serve notice without giving a reason.
You have to give a reason, yes, correct.
And those reasons, or the permitted reasons, do they cover everything really?
Realistically, yeah. I mean, as I said, if someone's in arrears with their rental, obviously antisocial behaviour, obviously breaking terms and conditions of your property, then you're still going to be able to get them out. It's not a problem. Okay. And if you want to move back into the property yourself, or you want to sell the property, you'll still be able to get them out under a Section 8 notice. Okay.
Now, there are some subtle changes within the Section 8 notices, aren't there? So, first of all, let's deal with the big one, rent arrears.
Rent arrears, the way it stands at the moment is effectively if someone's in arrears and you go to court and then they pay at court to clear their arrears, it gets thrown out of court. The way it's going to change, they'll only be able to do that 3 times and the eviction will still go ahead. So you won't have this ping pong going to court trying to get them out under rental arrears. If they're consistently doing it and if they wait till they get to court to wait till they pay their arrears off, they'll still be able to get them out, basically.
Okay, so it's closing down a loophole where tenants would run up arrears, pay themselves just below the 2-month threshold on the day of court. It gets thrown out of court because the previous test was for Section 8 notice to stand, you had to be 2 months in arrears at the point you served the notice and at the point you stood in front of the judge. Yeah,
so basically 3 strikes and you're out anyway.
I mean, it's still a lot of hassle for landlords to have to evict someone 3 times over.
It is still a lot of hassle, yeah.
So Section 8 is still 2 months rent arrears?
2 months rent arrears,
okay. And they've just closed down a loophole that a very small number of tenants had been exploiting.
Yeah, I mean, to be honest, in our experience, the amount of evictions that I've carried out on the rental arrears in the years that I've been into it has been quite small, to be honest with you.
So tell me, what else has changed within the Renters' Rights Act?
The other big thing that obviously has been bandied about in the press is a tenant's right to have a pet.
Okay.
Now, for some people, they've thought, oh my God, we're going to have to accept people with pets. You can still give grounds of refusal for a pet. If it's not suitable property, the pet is too large, or the number of pets. Okay. So, but you do have to give a response to that, and obviously a good reason why the refusal will be going ahead.
So we've got a lovely 2-bedroom apartment there in the window. If I've got 5 Great Danes, can I move in?
It's just not going to be suitable property for them. Yeah. There's also obviously a condition in head leases in some of the blocks that you can't have pets, or that they need a pet licence for those particular properties as well. So.
Okay, so a landlord who is governed by a head lease can still refuse pets?
Yeah.
Okay.
So some landlords have turned down people with or tenants with pets simply because they don't want any pets. But quite frankly, in my experience, that sometimes if they have that blanket ban, it means that they turn down, in some cases, very, very good tenants for the sake of a small pet, which I think with a more open-minded attitude, obviously if a property is wholly unsuitable for several dogs or several cats, obviously there's good, just reasons for that refusal.
Okay. It's not just pets now that you can't discriminate against a particular tenant for, is it? So
you're not allowed to discriminate against people on benefits or people with children.
It was always the case you couldn't discriminate against people with benefits.
No. I mean, you have to give them. They have to. Any tenant that applies for a property has to pass referencing.
Yeah.
Whether they're on benefits or not on benefits, and they're not discriminated against. It's just whether they would be able to pass referencing.
But even before the Renters' Rights Act, you weren't allowed to just blanket discriminate. We can't accept anybody on benefits.
You're not allowed to blanket refusal. It's just on their affordability.
Okay, so has that actually changed within the Renters' Rights Act, or have they just strengthened that legislation?
I think they've just strengthened it, really.
Okay.
Yeah.
So, in effect, that's not really changed much.
No, not really. No.
Tenants with children?
You can't refuse unless there's reasonable reason for it. High-rise apartment or near a working farm or something of that nature.
And is that a new provision within the Renters' Rights Act, or is that existing?
Just guidance as you just can't refuse. There's no discrimination allowed.
So other big changes within the Renters' Rights Act?
The end of advance payments.
Okay.
Advance payments.
This one's a bit more troublesome, isn't it?
It is a little bit more troublesome, and the reason why is because we have tenants that come from abroad, or they are self-employed. They have less than 12 months accounts, and we can't reference them or we can't pass them on referencing. So the way that we've got round that is for them to be able to pay 12 months in advance. That's going to be stopped. So they will not be able to take advance payments. Now, this is going to cause an issue for a lot of people that are coming in from abroad, or they haven't got a guarantor, etc. So that is going to be an issue. There are ways that we can get around that by offering a rent guarantee scheme, etc. And that is something that we are looking at Knight Edmonds to be able to offer to tenants in that situation. Okay, well, Victoria, thank you very much for your time. That's okay. And I hope that's been informative and hopefully reassuring any landlords that are a little bit apprehensive that they're going to be completely suffocated by huge amounts of new onerous legislation. It's if you know the legislation and you're familiar with the legislation, it's not as bad as you think. No, it's not as bad as you think. No. Thank you very much.